Air. Brian and I, we were just getting carried away talking.
Yeah, Sam, are we
Uh,
even on the air? That's a very TV centric sort of thing. We're on the tubes. We're on the wires. I
we're
would
live.
I will give you that one. We are live.
We're live.
Yes.
All
Okay.
right.
All right.
And we were just talking about a few things. Obviously, a lot of action in our office. We're coming on the
H1B
last week
season.
of our H1B filing, trying to wrap up that, trying to make sure everybody's been taken care of, looking at what if and anticipate, not react. That's the
Hmm.
name of the game,
Hmm.
right? Get ahead of it. So
Yeah.
we've been doing a lot of that in the last couple weeks. And today at 6 o'clock, we're here to talk to you about questions you have, concerns you have, talk about current event and immigration law, focusing on employment immigration. But if there's things that are interesting outside employment immigration, we want to talk to you about it because the world is interconnected, Brian. Nothing exists in vacuum. Clearly, a big event in family immigration, like the one we're going to be talking about today, is going to affect employment immigration without a doubt.
Yeah.
We are going to be focusing today on the Biden family unity
Policy. It's really a policy. It's not a change in law.
policy. Yeah,
Yeah.
it's smartly drafted to avoid legal challenge. The theme underneath this is we're just using laws and tools in our disposal all along. We just never
Yeah.
have done anything. We're not introducing a new idea.
Yeah. So maybe yeah, I will maybe dig deeper into that. So basically, the family based adjustment of status conundrum is that some people who, in order to adjust status in the United States, they'll forgive unauthorized employment, they'll forgive overstaying a visa, but somebody has to have entered the United States legally. And if somebody didn't enter the United States legally, well, they can't adjust status in the United States. And what they're using is the concept of humanitarian parole to parole people into the United States such that they can apply for a green card. Essentially, they're giving a very, very, very deferred, not quite admission, but definitely a parole, which would also allow you to adjust for humanitarian reasons. And that's
Yeah,
built under the law. It's any sort of humanitarian reasons can be it. The great example of the one that's used a lot is the military parole, spouses of military folks, and now they've sort of have this new version of it. Here's another set of grounds that we think would make a good humanitarian argument for paroling you in after the fact, despite the fact you didn't enter in legally. Spouses of U.S. citizens.
and we have had good experience with that, with the parole practice in our office.
Yeah.
Most recent of which is a parole in place has been approved for a wonderful family in the military,
Yep.
and a prior humanitarian parole was approved for a young U.S. citizen who have had cancer, and we were able to bring her mom,
Yeah.
although she was not allowed to enter the United States for complicated reasons beyond her control, to be honest with you. And she's
Yeah.
a highly respected professional in her country. But we're able to bridge all these and bring her here on a parole,
Yeah.
humanitarian parole, to be with her last living days of her daughter,
Yeah.
which is a huge thing, right?
Yeah, I mean, I guess
So,
you're underlining the versatility of the humanitarian parole policy. It was able to help somebody who had entered the United States without authorization to basically get paroled in by just filling out a form and sending it to the government. But I was also able to help a woman who couldn't get a visa to the United States to get a parole document that would allow her to come here and
yeah,
be with her
I think
daughter.
I think I think
Versatile.
yeah. Then the mother's green card was approved,
Yeah.
but we were able to parole her in, even though her green card was disapproved,
Yeah.
was not
Yeah. They
approved
couldn't do it through
for
through the for consular processing. Yeah.
inadmissibility issues
Yeah.
that are highly technical.
Yeah.
But the parole in place is a tool that have existed for years
Yeah.
in the US in the books and have been used, and our office has been using it successfully
Hmm.
before the Biden law.
Yeah.
And obviously, we're going to be using it a lot more now that the Biden
Yeah.
administration shined a floodlight on it and
Yeah.
said, oh, we got this tool right here that we haven't been using. And what else other than the spouses of US citizens that we should give them a humanitarian consideration?
Well, I mean, the one I can think of that from maybe about a year or two back was the extraordinary circumstances EAD was something that's sort of on that same trajectory. They sort of said this program's out there, nobody's using it, and it sort of massively lowered the bar, essentially, in saying, here's a scenario somebody who could qualify for a extraordinary circumstances EAD. You've been here for a long time, you own a house, and you have U.S. citizen children. You know
Yeah,
that
yeah,
that that sort of thing. So I guess it's one of the cool and interesting things about our work in general. Or it's one of the complex things. It's people always think the law is static and there's very you know everything is very clear how everything works always. No, it matters who's in charge. They basically can say, oh, we haven't changed the law, we haven't changed the regulations, but here's our interpretation of what's out there, and that can result in disparate results changing depending upon who's in charge.
yeah,
So
absolutely, absolutely.
I guess we should
And
go ahead.
yeah, so again, we have to maybe spend a moment or two in the next few weeks, allocate time to talk about what to expect with a future Biden administration if they're reelected, what to expect with a future Trump administration if they're elected, what's the trajectory in these two no third option available for this country to have as a president, and what's that going to look like
Yeah,
for you. But this today, we're going to be going over what is it? What's the requirement in the Biden administration that they put in,
U.S.
Brian? And I'm
parole.
looking at my other screen here, which has a nice, neat PowerPoint presentation that Joe Morhart,
Attorney
uh,
Joe
Attorney Joe Morhart
Joe
in
Marhart.
our office
Yes.
was so kind to put together to kind of help us out.
Yeah.
But we were talking last week. How many people is it going to impact?
Yeah.
And I said 700, maybe 500,000
Somebody in our audience said, I think I think saw 1.1 million.
million. Yeah.
Yeah.
So it looks like the settled number in the media is
Yeah. 500,000 non-citizen spouses and 50,000 children. Huge.
yeah. So half a million
Half a
adjustments,
million. Yeah.
Brian.
Yeah.
Half a million adjustments.
Yep.
Um, yeah. So so
That's
that is going to
absolutely.
be
Yeah, but that's huge. Oh, I guess one of the things I should mention, Sam, is what do we know about the requirements for the program? We kind of had suspicions, but we last talked on Monday just before it was announced on Tuesday. So go into those real quick. So there's three requirements that we know of for this program. One is to be present in the United States without admission or parole, and that's the immigration way of saying that you entered without authorization illegally. Essentially. So number two is they've been continuously present in the U.S. for at least 10 years as of June 17th, 2024. So there should be no rush over this policy. It's only for people who have been here for a decade since June of 2014. Sam, how do you prove you've been in the United States for a decade?
well. I was hoping you go down the list before we go down those
Okay.
questions,
Okay.
because already I have about half a dozen questions in my head
Okay.
similar to that one. But let's go through the third
Okay.
criteria.
Okay. And you must have had a legally valid marriage to a U.S. citizen as of 6/17, 2024.
Okay.
So, yeah.
Okay. Excellent.
Yeah.
So for those who are listening, they may say, "Well, these are easy requirements,"
Yeah.
and for many people, it will be easy, but not for everybody, because we lawyers love nuances.
Hmm.
And let's start with the be present in the United States without admission or parole.
Yeah.
Okay. So I have a case who somebody entered the United States and lost his passport.
Yeah, I got one. I got one of those. Yeah,
Well, we all got one of
yeah,
those, right?
yeah.
Has no evidence that he was inspected. He went in to apply for a green card based on marriage. They denied him. They said, "You don't have any evidence you were admitted.
Yep.
Can that person apply?"
That's well. Again, I'm working on a similar case to that right now, and um, I would say yes. If you cannot prove you've been admitted, you haven't been. You know, and it's the burden of proof is on the applicant, right? I mean, what I want my client to
Well,
concede.
I mean, we don't want to board.
I'm just spitballing here. I mean, well, Sam, let me put an asterisk here. One thing we know for sure, one thing we don't know is what the complete policy looks like. And they say there's going to be a posting in the Federal Register. We're going to get more details beyond these 3 bullet points and
Yeah.
requirements that we have. So there's that.
But that's a very interesting question. That's really a question. I mean, your logic is very sound,
Yeah.
but the government, I can see the government easily saying, you haven't you just told us you were admitted. We cannot approve you because you told us you're admitted, but you go to the admitted application. Well, you don't have a proof you're
Oh,
admitted.
okay. And this is when congratulations, Officer Sam. Attorney Brian's off to the side of the interview here, and I'm going to say if I'm anticipating they're not going to deny the case right there,
There's
but
no third option, right?
no, yeah,
You
I can
you
say yeah.
choose. You government choose what I am.
Yeah, respectfully, officer. So you're telling me they haven't? That you're telling me they've been admitted? Then, if they cannot be paroled into this program, that you're telling me that they've been admitted? Then,
Of
and
course.
if they haven't been admitted, parole them right now.
Okay,
You know.
so Officer Sam says, the burden of proof is on you, Mr. Bryan. Prove to me that you have not been admitted, or prove to me that you have been admitted. But you haven't proved, you mean you haven't been admitted, and you haven't proved to me you have been admitted. I
Um,
cannot process either application.
Officer
And
Sam,
I am ready for my break right now
Officer
because
Sam,
I'm
Officer
taking a
Sam.
union break.
The Federal Register. Let's look at the Federal Register that has just come out to see what the actual requirements are. Because you're right. It's classic like nightmarish. How do you prove a negative?
Yeah, yeah, yes.
Sort
And
of
that's
thing.
going to be a challenge for us on a lot of the cases.
Fingers crossed. It's not so bad to figure out. But I have a guy who.
I think it's all going to depend on which administration we're going to have.
Well, this is
These
policy though, Sam.
analysis
It can go
policy, yeah,
away.
but the devil is in the details.
Yeah.
You go in now. The officers, you're giving clear instructions about how to implement the policy. You get the policy, you get the implementation of the policy.
Yeah.
Number two, continuously. You asked me continuously present in the United States for at least 10 years as of 6/17/2024.
Yeah.
So last time we dealt with continuous presence, and I'm trying to remember the law, and I'm not remembering it, and that's been a long time ago. There has been some ruling, so there's some history that a brief departure from the U.S. does not disrupt the continuous presence requirement.
That
So
sounds vaguely familiar to me, like something I may have read there at some point. Yeah.
INA 245I, maybe it's the supplement A.
Part of
Um,
yeah. I do. That sounds familiar.
that
Familiar to.
also required continuous presence.
Mhm.
So because people were crossing the border and crossing the border back.
Yeah.
Well, I had to go back for my mommy's birthday for a week, and then I crossed the border back illegally. So that is not disruptive of your continuous presence back then. So I can expect some clarification that says you don't have to be here every day for 10 years, nor do you have to prove you're here every day for 10 years. You just have to show a kind of a general continuity of presence,
Yeah.
potentially. But again, we don't know until we see the regulations. If the regulations is going to go into that detail, the regulations may not, and
Yeah.
then you're going to have to go back to what they're going to do
Yeah.
after.
Then
I'm
we're in the.
sorry, the Federal Register. I'm sorry, not
Oh
the
yeah, and then we're
regulations.
in our fun little immigration attorney zone where we don't know what the policy is, and it's up to, the individual officers to decide. And some of them are, and this is something that, speaking of things, I was going to say, Sam, this is something that could be litigated. Certainly, this is going to be litigated. In fact, I'm pretty sure I read something about a challenge lawsuit on this.
Oh, no, there's no question about
Yeah,
that.
if I haven't it certainly exists in somebody's on somebody's computer right now.
Or somebody's drafting, exactly right.
Exactly.
So have been legally married to a U.S. citizen as of 6/17/2024.
Yeah. And well, Sam, I'll tell you how that can be nuanced. I had a gentleman
Oh,
and his wife in our office about 2 weeks ago, and they came to us because they had I-130, but she was a U.S. citizen, he was not. They had, I believe, two I-130 petition denials, right? And the problem he had is that he was divorced in his home country, and the problem being that divorce didn't meet
was not
international.
recognized.
Yeah, he didn't
Was
have
not
a
was not
proper court
recorded.
order. It was like a ceremonial cultural divorce, but it wasn't recorded. And
Sounds like an
basically,
Islamic divorce.
I don't think
Because
so.
Islamic divorce, you
But
have
same.
to only say "I divorce you."
Yeah. essentially it was something similar to, I don't think it was Islamic, but something similar to that. And these folks came to our office, and I said, guys, here's your problem, and I don't think you're legally they haven't been here in the guy hasn't been here in the United States for 10 years, but the problem they had is their US marriage. I don't think it was considered valid because of the issue of that sort of issue there. So Sam.
First cousin marriages in certain states.
Mm-hmm. Oh, that's a
Although,
yeah.
so it's very interesting. So, have a legally valid marriage to a U.S. citizen. If you're married to two first cousins married in a state that accepts it, I think most states would recognize it.
Yeah, Sam. Let's turn this to the. I want to segue to the employment, because I want to talk about how this impacts and a bit the employment stuff as well. But
Okay.
we've encountered the marriage concerns in employment immigration. In the last couple of years, we had an H1B, and somebody was married to somebody who was, I think it was a
First
cousin,
cousin, yeah.
first cousin.
H4 was a problem.
Yeah, and then they said, okay, we're going to approve your H1B visa, but because you're going to live in a state where cousin marriages are not permitted, we're not
We're
going to
not approved H4.
approve the H4. And the fun, I very much love the solution we had on this one. It was, hey, let's go file an H1B amendment. Move you're going to move to a state where cousin marriages are allowed, and that's where you're going to live and work because his job
And
allowed it.
that worked.
Yeah,
That
that
was approved.
worked. Yeah,
That worked, yeah. Which is crazy, right?
yeah.
It's crazy.
So
Yeah. So, yeah. So all those issues we're going to be dealing with when we deal with family immigration. But the biggest impact, as we have talked last week, clearly, and has to do with the question of bandwidth and capacity, Brian.
yeah, and what are all in this a spot where USCIS has demonstrated they have a very bad processing times is advanced parole, because the parole in place, the humanitarian parole we're talking about, is something that is filed on Form I-131. And raise your hands if you think the I-131 processing times are absolutely abysmal. Ooh, 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 me, because they are. And Sam, just as a sort of a fun side, USCIS is doing layoffs in. I read about layoffs at the Nebraska Service Center, which I swear USCIS Nebraska layoffs. Let me see if here it is from the local Nebraska. Immigration workers in Lincoln worry layoffs elsewhere spell trouble for them.
Are you kidding
Um,
me?
I kid you not. I know I've seen. Here's another headline: Nebraska workers protest immigration workers layoffs in California. So maybe that's what it was. But there you go. I could have swore I saw about layoffs in Nebraska as maybe it was just USCIS. I'm seeing again. It's a story I've seen. Not something I think that agency needs right now.
Or ever?
That's for sure. Yeah. Yeah, Lincoln immigration. This is again a local news headline there, but it's something I had seen. Lincoln immigration workers protest layoffs. Local staff will be cut in half. Union says.
Holy moly!
Yeah. So maybe I'm going to engage in what I can call a little bit of conversational archaeology. How did we get here? Biden family immigration unity plan to I-131s to massive backlogs to USCIS layoffs in Nebraska, which
It's
uh,
insanity.
yeah,
Yeah. I mean, clearly. Well, here's the question for you, Brian.
sure,
Do you think, just to let everybody know, you had to have the I-131, which is the parole in place, approved
yeah.
before you applied for the adjustment? Is that going to be the case?
Oh yeah, that's something we were talking about as well. And thank you for moving us, keeping us on that topic, Sam. So in the world of immigration, there's a eligibility at time of filing, requirement generally. And if you read, it's INA 245 is the law that covers adjustment of status, right? And INA 245, this is me saying and repeating it so I can go look up the text of it. I know it says that they must be, here we are, the status of an individual who was, past tense, inspected and admitted or paroled to the United States, yada, 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 may be adjusted by the Attorney General. So it seems to be a prerequisite. Maybe you could take them in the same package. But you file them all together. First, they would adjudicate the parole, then they would adjudicate the I-130, and then they would adjudicate the adjustment of status. Maybe they could do that.
Well, the I-130 first.
Yeah, but then again,
But
eligibility at the time of filing the I-45, you can't. Arguably, you
so
shouldn't. Yeah,
so it all depends on what the Biden administration wants to do. If
yeah,
they want to issue EADs for these people or not, right?
yeah, yeah. That's a
If
very,
the,
very good point. Yeah.
because if they're gonna sit on it for a year, the jubilance
Yeah,
of the U.S. citizen and the U.S. community who's married to undocumented foreign national is going to fade,
yeah. I mean,
and the impact on votes is going to become shaky because you want to get EADs.
yeah. You want
Yeah,
people feeling warm in their belly that they're full of
I mean
immigration
that's
benefits.
jobs,
It's political.
right?
Yeah, yeah,
You know,
yeah.
so that's going to be, and then the driver's license, status, social security number, rights to be that immediately
Comes
before
with
they
them having
approve.
a pending adjustment of status process. Yeah,
Yeah.
yeah, yeah,
So while we fight the physical presence and the proof and all that, because we can probably make a prima facie case, which meaning in English, a simple presentation to get this in and then deal with
an
the
RFE or
additional
yeah,
evidence they may need if they need additional evidence and give the client more time to assimilate
yeah,
and assemble this information.
yeah.
All right. So um, employment immigration clearly a bog down in the processing time, loss of appetite to move adjustment of status visa bulletin dates forward.
Lack of visa availability is as well, arguably. Back half of the year,
But
last
you can be
quarter.
aggressive. You can say, "Let me forward gress it and then retrogress it later,"
It's a matter. Well,
and
Sam, it's a
capture. Yeah, it's a matter
we.
of policy, right?
Yeah, it's a political beast, that visa bulletin, in some ways, as far as we know, as far as we
But
believe.
any appetite to do that now has been probably not available. I mean, USCIS is going to say, please don't move this visa bulletin. I got 550,000 adjustments in my warehouses. I don't even have room for them. And
Yeah,
you're going to move the visa bulletin in another 6 months? Are you kidding me? So I can get another 50,000? I don't have room for them.
you know,
Or 100,000. I don't have room for them. Please don't do that. So that is going to be a really, when the rubber hits the road, that's really going to be the impact is that maybe a slower moving visa bulletin, Brian.
I think that's a distinct possibility there. Sam, I just had a sort of an epiphany that people might want to ask us about. It's, can the issuance of more family-based green cards, to spouses of U.S. citizens and 50,000 children there, as estimated, can that impact the availability of employment-based green cards?
The answer is yes, because the cross flow
Well,
is going to be less.
but these are immediate relatives. So
Or the, or,
there's visas
but,
always.
but isn't this, well, we always had the maximum number, right?
Yeah. So as I
So
recall,
maybe not.
so yeah, so technically, in theory, it could, but we always, as I recall, this has been a while since we've been asked about this, and
Hmm.
I'm the guy who brought it up, so bad upon me. But as I recall, there is actually a number of immediate relative visas available that get sort of gobbled up. There's still always going to be visas available for immediate relatives, but as I recall, there's like a number that where if you don't hit that number, it would be available for non-immediate relatives, lesser desired family visas, and if those went unused, it would go over into the employment category. Is the bottom line there. So no real impact on employment. I don't think there'd be any real impact upon employment visa availability. Just the processing times, as they in theory take 500,000 new adjustments, as well as 500,000 I-131 parole applications as well. That's where it comes down for me, I guess. So
Yes.
yeah,
All right, sounds good. So we jump on questions, Brian. What do you think?
I think we should. We had in our notes, in our title here, we're going to do employment based FAQs, and well, but there's people who have questions, and I'd say we hit their questions first, and we'll maybe intermix in some of our favorite FAQs in there. Fair
Sounds good
enough.
to me. Yeah.
So there we are. From AN, the first one we have here. So, part one of two. My case is related. Is my question is related to portability of priority dates. I filed I-485, and USCIS assigned me a priority date based upon the recent I-140. Had to request them to correct the PD to an earlier I-140 approved. Okay, which wasted 9 months when I was current and is a USCIS error. Can I ask to expedite my case based upon USCIS error? So, well, Sam, what are your thoughts?
You can ask. The question is, do they care? I think there's a good foundation for that, in my opinion. But there's other ways to do it. But go ahead, Brian.
I think, well, I have a couple layers to this as I see it. Firstly, layer one is was anything delayed? Bottom line, you were always entitled to the earliest priority date you had from you had on your prior I-140, right? And meaning you were never lost it. However, whether or not they knew your priority date was current, I guess is fundamental to the question, and we don't know the answer to that.
Well, I made an assumption,
Okay.
which kind of skipped your first layer,
Yeah.
that he may have a adjustment status pending,
Yeah.
and but that's an assumption. And if he has an adjustment status pending, can I expedite my case, meaning the adjustment status,
Mm-hmm.
based on this error,
Mm-hmm.
meaning USCIS, you should have been acting on my adjustment
Mm-hmm.
9 months ago.
Mm-hmm.
Now I'm behind 9 months. Go ahead and move my case.
Yeah.
So with that adjustment, can you ask him to expedite based on that error?
Kind of depends upon the facts to me because uh,
Because he's current.
yeah, he could, but I mean, I guess I got to get his other potential fact scenario out of my brain, Sam. If he only filed his adjustment of status, you know, 9 months ago, that's like within normal processing times based upon wherever you're at in the country. I guess the bottom line is I'll give you my answer, Sam. I think you can make the request. I don't think it's a very good chance they're going to. It wouldn't sound.
I have to
I would
agree.
tell somebody exactly this. You can make that request. It's not crazy to make it, but they are very reluctant to admit their own error.
Well,
Is
you're very unforgiving today, Brian. You're very tough
Am I?
review. Yeah, you're giving it a very tough. Give this guy some hope.
Make the request. The worst
I
they can
would,
do is say no.
but I have to admit you're correct.
Okay. So Sam,
I have,
you're being overly optimistic. You're giving people
I am
false hope. Um,
correct,
but
correct. You're right. You're very right. False hope. I mean, who? I mean, USAS is not going to give a hoot about the 9 months. The question becomes, are you in a situation where you are going to be foreclosed with a retrogression, in which case you need to run to the court because you have an error by USCIS you can point to that they've delayed me.
yeah,
Your case is
that's
a
a
lot
lot.
more effective.
Yeah, but I mean, here's the thing. The thing, though, I imagine the government response is, again, it depends upon whether this person filed their I-45 and I-140 at the same time. I mean, because if they took your I-45 case based upon an I-140 that's not priority date current, as in my hypothetical, if they didn't reject your I-45, it means they knew your priority date was current the entire time. If you get what I'm saying, Sam? Again, I don't understand
The
it.
devil is in the details. We need more
Yeah,
facts.
yeah.
But if you potentially have a good mandamus argument, potentially we
It's
need
more
to know a
compelling
lot
in
more.
mandamus action than
Yeah,
expedite
yeah,
request,
yeah,
for sure. But I can
yeah.
imagine the government saying, "No, no, 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 we weren't delayed. We weren't delayed. It's just normal processing stuff." And
That's
that
our job.
that's
We
under the
will,
law.
yeah.
He always had his priority date. Just like I said earlier.
It depends on the facts.
Yeah, yeah,
Depends on the facts. All right. Hopefully, AN was helped with some guidance.
yeah, yeah.
All right.
Wishy-washy attorney answers. Sorry.
Yes.
Yeah. So from Arindam, currently on EB2 with priority date of June 5th, 2015. Few months ago, on my request, company's attorney reviewed my overall profile.
Hmm.
And I like where it's going. Decided to give a try for EB1A, and my EB1 petition is currently being filed. I have 9 reference letters, and some of them, mostly the ones from corporate companies, are not in company letterhead. It's on printed plain paper. They are signed on it, sent from their official email ID along with their CV. Will be a problem for not having it in company letterhead. And I'm going to one sort of bit more question here. So reference letters, which are from academic field like professors, researchers, are in company letterhead. So what do you think, Sam?
I think that is a red herring. I don't think that is going to decide the case one way or the other. I think the overall of the case, what does this letter says? What are is it a convincing? What does it
Is
talk about?
Yeah, I'm more interested in, what does their CV say? If they're impressive on paper, sometimes corporate letterhead is useful. I'm working on one right now where the guy does a lot of work with state governments, and I am begging him to ask his recommenders who work in state government to get it on state letterhead because it gives it some gravitas in terms of the importance of his work. If you can get the state governments from multiple states to go, yep, we know this guy. He revolutionized XYZ. It's compelling in terms of the importance of something. If our statewide governments recognize them, for sure.
And the example I'm going to give you is a true reference to a case I've handled. Um, Sometime a very reputable
Hmm.
author that wrote your letter who is retired. He doesn't work anymore.
Yeah,
But you know what? Look him up. Google is going to blow up when you put
yeah.
his name and search for it. He doesn't need to be on letterhead. So I mean, it all depends on the overall of the case. Every case is different. EB1 is almost like a painting, and every stroke of color is a piece that gives you the picture. And to analyze a stroke of color without looking at the whole thing doesn't do the picture
I was
justice.
preparing a very similar metaphor, Sam. We're on the same wavelength today. It's yeah. It only those things can. It's like a percentage of a percentage that those things can influence
Yes,
things on.
I agree. I agree
Yeah.
with you.
Yeah.
Yep. All right,
So
jumping on to the next one,
yeah,
Brian.
Excuse me, Chandra Banu. Any predictions on EB1 India reaching February 2023 by December 2024? Visa Bulletin is where Brian goes. He slows down to buy himself some time to Google Visa Bulletin because he didn't have it up available. Sam?
Well, I mean, I can comment on by October. I'm more comfortable commenting on by October, December, because beyond October, new fiscal year, then how things transpire beyond that becomes very difficult
Well,
and muddied.
Sam. Here, I will put some data points in your brain. Right
Hmm.
now, the final action dates for EB1 India are in February of 2022. You know,
Yeah.
um,
Well,
but again,
so I just jump into October 2024 and say it is not likely to jump to February
yeah.
2023 by October of 2024, and then I'll take the second jump and say, will it make a difference 2 more months beyond October? And I would say no.
Maybe think towards January is be more likely when they the quarters of the quarterly visa bulletins are the more
Or there's a little bit more serious move, and we can even look
yeah.
at it more.
I
Yeah,
mean,
yeah,
I'll comment on the positive factors.
yeah.
EB1 for the rest of the world is current, and we saw a big old leap forward in India EB1 just this month. But it is, I guess, the other side of the coin is, well, they say it themselves in the Visa Bulletin. Just because you've seen something in the past, don't expect it in the future. You're asking for a year of jump in about 6 months is the bottom line. That's rare, frankly.
And it goes without saying, if it jumps a big jump recently, is not likely to jump another big jump
Yeah.
recently,
Yeah, yeah,
right?
yeah. Bottom line is, Chandrabanu. I think Sam and I would agree. Interesting quarterly visa bulletins are the interesting one. The most interesting visa bulletin is October. That's October one when we just are bracing ourselves for what's going to come because they're always interesting.
And with the current family-based immigration, Brian, I am more reluctant honestly, to support any big movements for a little while, in my predictions.
Yeah.
All right, let's take the next one.
From Jayanti Kumar.
Kumar. Good
Yeah.
evening, both of you. Good evening to you. Is it possible to move I-45s to India consulate processing if needed? Prior to this 2014 July, last day, does that impact 45 approval? Um, okay, so Brian, what do you call moving an I-40? So is it possible? The answer is yes and no.
Agreed.
Yes
My
and
version
no.
is kind of maybe, but yes.
Yes and no. Kind
Yeah.
of, maybe, yeah, sorta. Um, and what is it called? The process with the
Well,
consulate?
consular processing, or you're talking about action on approved petition, perhaps.
Yeah. So, and the USCIS does not like that. State Department does not like that. But I don't want to terminate. Would you terminate the 485 and start the consular processing?
There is no requirement that you have to, as I don't believe there you can pursue consular processing. So, Sam, I feel like we're having a very intense immigration attorney talk, and our audience has no clue what we're talking about.
Okay.
Talking about.
All right.
So,
Simplify.
okay, so let's maybe answer the first question. Get everybody on the same page as us. Is it possible to process an I-140 employment-based green card through the consulate? Yes. How do you do that? Uh,
I-45.
not through not through the consulate, not I-45 through the consulate.
You just said, is it possible to process I-140?
Yes, it is possible. It's possible to get an I-140 based green card through the consulate by doing consular processing.
I see.
But okay, um, is it possible to send the I-45 to India to finish up the process there? No, because I-45 is the process by which you get a green card from within inside the United States. But it is possible to start up an alternative green card process through the consulate by filing a form with the government that says, "Hey, I'm actually intending to apply for a green card through the consulate," which we would call filing an action on approved petition to tell the government, "Hey, that one I told you I was processing through I-45, actually send that to the consulate so I can apply there." And it shouldn't necessarily require the denial of the I-485. Um, yeah, but
I agree.
and does that impact I-45 approvals? And does it would that process impact I-45 approvals, Sam?
The process in and by itself shouldn't.
Yes, by
But the
entering into it.
approval of the immigrant visa processing makes the I-45 superfluous,
Yeah, moot.
obviously.
Yeah.
Yeah.
Well, yeah. As soon as you arrive in the United States, you're a green. You're so. I guess you're a green card holder. So it's possible to open another process by which you, instead of doing I-45 inside the United States, instead your green card process ends by you going to an interview at the consulate, and where they will interview you and say, "So you're going to work in the United States for company XYZ pursuant to this I-140 petition?" Uh huh. They're still offering that job. Yep. Here's a letter. Here's an I-4. Here's a letter from them confirming it. Okay, cool. New visa type of visa stamp in your passport, immigrant visa, and by the time you enter the United States, you're a permanent resident from day one. They'll send you the green card in the mail in a couple of weeks after just completing a very basic form. You're already a green card holder as soon as you arrive. It's just getting the card in your hand. It's an administrative issue. So, but what do you think about doing that, Sam? About converting to
Well,
consular
I need
processing?
to know their personal situation a little bit more. I mean, obviously, there's more to know
Yeah.
because personal circumstances dictate, how you're gonna proceed with your life. If it is in search of a faster route, no. But if
Oh
it's
yeah.
in a situation where there is a pressing circumstance that requires them to be abroad with a sick family member or etc., then we're gonna have to do what we're gonna have to do. Yeah,
Yeah.
we will. Yeah.
I mean, there's that interesting question of, there's no requirement that you, with once you have a pending I-485, that you be in the United States for any duration of time. You are not a permanent resident. You're not required to be in the United States, but you can't help but wonder if the government would scratch its collective chin and say, if you say your I-45 is pending for, you spend 2-3 years outside the United States. They call you for an interview, and well, you've spent 2-3 years outside the United States. It'd be very interesting in thinking about how they'd approach that, and whether it's a good idea to pursue something like that.
Especially exactly, and that where it's going to be interesting. Yeah.
It's a very interesting, like, hypothetical, and one
Hmm.
that one that I would say to you, my client, you should probably avoid being in anything that an attorney considers a very interesting hypothetical. You know?
Not only that, but a situation like this, before you make decisions, you got to consult with an attorney. You got to go talk to a lawyer,
Yeah.
and have a conversation with a lawyer that you are comfortable with, that can advise you on what you should do, and maybe regularly be checking with them, so there's no change in policy, because these policy changes can happen all the time. Just that reminds me of one of my very smart clients. We've written a contract for them 10 years ago to use for their, it's an employer to use for the
Hmm.
employees, employment contract.
Hmm.
And then 10 years later, not knowing they've been using it, he sends it to me and he goes, "What do you think of this contract?" And I emailed him back and I said, "It's a lousy contract." He emails me back and he said, "You wrote that 10 years ago." And I replied, said, one, it's been 10 years. A lot has changed in 10 years. Two, no, what I send you is completely different. You tinkered with it for 10 years. You changed this paragraph. You changed this thing. You added this. You flipped this around. I have the contract I sent you 10 years ago. Here it is. What you gave me is what started to be my contract 10 years ago. It became your contract now, and it's a lousy one.
Yeah.
And it has a lot of things wrong with it. So you always need, if you leave the country, you always need to check with your lawyer. If you have an adjustment status filed, you need to, at least you guys are here spending some time with us because you want to learn and be stay current, and that's a wonderful thing. But also you need to check with your attorney and say, "Hey lawyer, I got this adjustment status filed 6 years ago, and I'm doing this. Can you just take a look at it, see what the heck am I doing here, where am I standing, is there a surprise?" uh, I think you should do that every 18 months, every year.
Yeah. Yeah.
It is a smart thing to do.
Yeah. Yeah. So Jonathan had a sort of a follow up, which is an interesting one from, at least from my perspective. Priority date July 2014, last
Hmm.
day. Do you
Hmm.
think my priority date would be current in the next 2 years?
Right.
That
It's a good
priority date
question.
has been current before.
Yes.
And my favorite thing to say is, all those green cards they gave away in prior years, it thinned out the metaphorical herd. There are less people they gave away, people with green cards, to people with priority dates after that and before it. Meaning, you know, that's priority date. Or meaning right now, EB2 and 3 for India. I'm going to presume India, considering just based upon the age of the date, of course, is in June of 2012 EB2 and September 2012 EB3. It doesn't sound absolutely crazy to me that it could get back there. I wouldn't, betting money on it. Well, when it comes to gambling, bet money you can afford to lose. But it doesn't sound. It wouldn't make me go, wow, wow. You know.
We looked at visa bulletin data one time, you and I, Ryan,
Mhm.
going back 15, 20 years.
Yep.
And we looked at how long it took for the green card to be issued.
Yep.
And what we've noticed is it ranges between 12 to 15 years
Yeah.
consistently.
Yeah.
I know there's some calculation that says 350 years.
Yeah.
I know that.
We live in the
Uh,
real world though, where we see results. Though
yeah.
I've been doing my
So,
job for, I'm closing in on 14 years, and the ones who I did green cards for in the beginning, well, I've gone to interviews with this guy, high five and saying, you didn't know this at the time because I didn't wasn't talking to you, but I was working on your
that's
green
right.
card, that long ago.
Yeah,
Yeah,
yeah. So yeah, so 20. What's the feasibles and what's his priority date?
2014, and so he's
So
10 years deep.
you just clock the 10-year mark. In 2 years, you would clock the 12-year mark. You have entered the realm of possibility based on historical data that you may get your green
Yeah,
card at
that's a
that
that's
point.
a good, an interesting perspective on it,
Yeah,
for sure. Yeah,
yeah.
yeah, yeah. yeah, like I said, nobody can predict, especially 2 years out. The
Yeah,
government can't. There's a reason why the government, puts out the visa bulletin on a month by month basis, because that's about how far they think they can predict,
figure things out, right?
essentially.
Yeah,
So
yeah,
yeah,
which is sad. Yeah.
yeah. So I'm gonna move on then to Wesley. Hi, Sam and Brian. Hi, Wesley. I submitted I-765 and I-131 renewal for my wife on May 10th at Texas Service Center and still haven't received the receipt notice. Are you two seeing receipt notice delays as well from your office? Yes.
Very
Uh,
frustrating.
yeah, we have sort of reports by which we track these things, and I mean, I just talked to somebody on Friday, Sam. This is a different kind of case, but I think it was at Texas Service Center. It was an H4 and an EAD for her spouse that was filed in the same envelope as an H1B. And what happened is with everything got there the same day, right? H1B approved, premium processing a week, and it took them 60 days to receipt the H4 and the EAD. This is after they and this they did this after we sent them. We told them, and we said the case hasn't come back. The case hasn't been receipted. Your conservative thing to do is file another case, and then after we file the next case, well, then they receipt the first set. Infuriating. Yeah.
What's going to happen when they accept these 500,000 adjustments? Just,
um,
just
yeah.
asking the simple question.
Uh,
Yeah.
chaos for sure, but it's always fun. It's always exciting times for us when these changes happen. I was just telling our assistant Alyssa about this, Sam. My idea is that about every 5 years some interesting blow up happens in the world of immigration law, and the last one we had was October 2020, and maybe we're getting that one a little bit early, you know uh
Nobody's ready for that.
yeah, it's supposed to take five years. So that's supposed to
Are we
happen.
are we into the 5 year
Well,
entering that?
October 2020 was our last big, employment immigration dust up, and we are closing in on 4 years since then. So again, maybe it's a little bit early, but
Hmm.
that's my crazy crackpot immigration theory. Every 5 years, from somewhere, something wacky happens and blows everything
And
up.
and then and then we work 24 hours a day for 60 days,
I
and
I
and then you know our paralegals say this is too much. We can't do this, Sam.
Yeah. Yeah, it's a great not a great way for the government to function. Have an explosion every
Every
metaphorical,
5 years. Yeah.
of course. Yeah,
Yeah.
yeah. So
All right. Thanks, Wesley, for the question. Let's take the next one.
yeah, from Empire, who always gives us good commentary on what we're talking about here. So if they agree that temporary departure doesn't stop continuous presence, doesn't that trigger the permanent bar? Yeah,
Well, unless the parole in place is approved.
yeah, yeah. This is yeah,
So it's interesting, but
yeah.
legal issues. We're going to see how continuous presence. Although I have to say,
They might be able to file an I-601 like waiver of. I mean, they might require you to file a waiver if on an issue like that.
so
Because
when, so um, when I mean, it's very possible that they can use a penalty, but it's not in the regulations because the supplement A, which is $1,000 penalty
yeah,
back
yeah,
in 2000 year 2000 1999, 24, 25 years ago, I think is in the regulations to pay
yeah.
$1,000.
I don't
So
think they're going to attach a penalty to this one because
they
you'll have
can't.
yeah, yeah. You'll have been paroled. You'll fix your issue. Yeah,
Yeah.
yeah.
So if you've been paroled, does that trump the inadmissibility? I guess it does.
Yeah, well,
Basically,
I mean, think of the paroles we've done successfully. The one person who from abroad coming to see her daughter,
yeah,
she was
yeah.
clearly, well, not clearly.
Inadmissible.
Yeah, found
She
to
was
be
inadmissible.
inadmissible for
Yeah,
very strange means by the U.S. consulate in your own country, and
yeah.
yeah, parole gets passed. You can be paroled
But is
despite.
adjustment, but does adjustment get passed? Becomes the question. So those are a good question, Empire. You congratulations, you got a job in our office. Give us a call tomorrow. We'll give you a job because you're thinking very logically.
Yeah,
So those are good questions. We don't know the answer
yeah.
until the continuous presence is defined, and whether or not departure and coming back. When they've implemented the bar. Before that, people were crossing the border, working for 6 months, and then leaving, and then maybe coming back, and
Hmm.
they're. But because of the bar, it trapped people in. It created the problem. It magnified the problem, where people were saying, "Oh, I'll take a risk and come back across the border. I'm not going to get caught." And then they go, for 4 or 5 months when the weather is nice in their country, and then come back, right?
Hmm.
Then the bar came and they said, no, I don't want to be penalized. I'm staying. The heck with it. So
Yeah,
that really created a bigger, it amplified our problems.
yeah, yeah,
This is an example of a law that doesn't make any sense.
yeah.
Um, all right. SIVA, Brian.
No, 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 no.
No.
Maybe you don't see my cursor. We're on this one from
Uh-huh.
Chianti.
Okay, yeah, I don't
So
see your question. Yeah.
yeah, can primary use H1B and can a primary H1B independents, wife and son, use their EAD AP while in the U.S. or crossing the CBP? Thanks so much, Sam and Brian. As I'm reading this, it's like the primary there's somebody on H1B with, I guess, a pending adjustment of status. Can the primary H1B person use their presumably visa, and the rest of the family use the EAD AP? That's how I'm choosing to interpret. What's your take, Sam?
Can the primary use H1B and the dependent wife use EAD while in the U.S. crossing? Yeah, the answer
Yeah,
is
yeah,
yes.
yeah,
Yes.
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 All right. Yeah, that's the pending H1B or slash H4 and pending adjustment status are independent grounds to stay in the country.
What about the other way around?
So can the primary use the EAD while the rest use H4s to come inside the United States and H4 EAD to work? Now, they shouldn't be able to. Do I think that customs might admit them that way? Maybe, but they shouldn't be able to.
Right.
If the primary person is not maintaining H1B status, so should their family members not be able to use their dependent EAD,
Correct.
status to come to the United States.
Yep.
Yeah, yeah. So, Empire again, a good steward of our conversation. Heard the layoffs weren't adjudicating officers, but contract workers. Maybe they're cutting roles that online filing will make obsolete. So, uh, I could have swore I read it. I was reading that the narrative is they're going to be replaced with contractors, because one of the headlines I'd read there was, the union was saying they're going to lose half their workforce, and those would be presumably direct employed government employees who would, of course, allegedly be replaced with contractors.
Can you retrain these contractors into other things that we need them for? Approving I-131, which takes 8 minutes to process.
Uh, I don't know, but call me crazy, Sam. I would say keep those employees, right? Then add on some contractors, to temporarily, uh, Sam. I understand. I-131 is the one thing I probably don't want contractors doing. I want your experienced folks doing I-131s. Their travel document. I don't want to give people false hope of
All
leaving.
what they have to do is pass a policy that says if we issue an I-131 and you are not in violation of your status, you're forgiven by virtue of the I-131 approval.
Yeah. So basically, you're hearing me being concerned that I would be worried that people be found inadmissible with a ill-issued, not smartly issued I-131. They'll leave the United States, come back, and the customs folk could go,
Just the
"Too bad, I
idea,
got you."
just the idea that you have to adjudicate the entire person's history in the
Yeah.
U.S. to issue an I-131 is absurd.
I would
You
agree.
think
I
about
would
it.
agree. I would agree with that.
Yeah.
I-131
Just
should
the
be
idea is so stupid.
I-131 should be a suit of armor that says, "I don't care. Don't care. You've given me this, and there you go. A free
Yeah.
pass is."
Or charge more money and get more resources.
Whoa, 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 Sam! Charging more money? They did
Six
charge more
hundred
money.
thirty dollars, six hundred
It's
forty
six.
bucks,
Yes,
something like
it's
that.
six something for the
620,
AP.
some kind of ridiculous. Six
Yeah,
six plus.
yeah. It is ridiculous, and a lot of like family based cases, they're opting to not do it just to save the cost, and also other reasons because it may not be a good idea. But yeah.
Yep.
So to Striva now.
All
Uh,
right.
yeah. Computer network engineer, entry level job offered 10 years ago, to senior manager or director on SAP technology, still IT job. Can that be considered same or similar job? Priority date January 2014.
Can it be considered? Yes. Can it be not considered? Yes. It really has to be. I mean, a director, I will be extremely nervous. For a manager, maybe. So I need the job description of each,
Mhm.
and I want to be left alone for 15, 20 minutes,
Yeah.
and then I'll give you an answer.
Oh yeah, I think that's yeah. And this to be clear, so Suiva clearly was reading my mind because he follows up to say above questions about job portability, I-45J post I-45 filing portability, and they say salary changes in above 3 to 4 times, as in 3 to 4 times the amount of salary.
Yeah.
Whoo,
So that is,
it's a
I mean,
factor.
so yeah. Well, it's a concern. Yeah, I would be. I mean, if it's a director position, I would be concerned.
I
But
will
the
be
solution is simple. I mean, file a new labor certification. If you have a visa bolt and you're waiting,
yeah.
just file a new labor certification. It has absolutely no impact on when you're going to get your green
Yeah,
card.
there's been scenarios. Well, he prior to date of January 2014. It's not that
Well,
far off.
yeah, but let's take about a year, year and a half.
Yeah, it takes about 2 years to get to a final approved I-140 at this point though. I
Fine,
think.
file that. If it needs to be filed, it needs to be filed. The sooner you file it, the
Yeah,
sooner. Yeah, I
I
mean,
mean, I've encountered this. There's a client, here in town where we encountered this exact scenario. He was like, started as a programmer analyst, and then he was, vice president of this. This was not a portability question. This was he was getting ready to file the I-45, and well, we warned them, maybe 2 years prior to filing the I-45 that this could, he's seeming like he's pretty far away, and they ignored us until he was getting ready to get all excited. And I said, well, could you really, in good faith, offer him that programmer analyst anymore when he's going to be vice president of this? Long story short, he waited some time and did a new labor certification. You know,
which
you know, yeah, I agree with you. If it's questionable, you can file a new labor
file
certification.
it as soon as you can.
Yeah,
Don't waste time.
yeah. Yeah, that and if you do a new labor certification, it's not a it's not a portability question anymore. It's a transfer to underlying basis question, essentially. Yeah,
Yeah, I
yeah,
mean, obviously, priority date is preserved
yeah,
with that one for the approval.
yeah.
All right, Brian.
So see what Empire has here. A question from Empire. How do you see the D3 waiver for DACA recipients and others to apply for H-1B will impact the lottery and the EB green card? So I heard about this vague rumblings of some sort of a waiver to
Why would the DACA apply for an H-1B? They have to get, and that's a status, so there has to be some kind of a parole in place, which is the D3 waiver is trying to do, maybe. But the parole in place gives you status, but but it does not give you.
well,
So,
status can get you an employment-based green card. You know,
but parole doesn't give you status. Parole gives you the right to stay in the U.S.
yeah,
Again,
but well,
the devil
they
is in the details.
yeah, yeah. I mean, okay, well, let's answer. Sorry, Sam. We jumped on the interesting legal part, and Empire didn't we didn't get to. How do you think it will impact the lottery and employment-based green cards? Um, so H-1B lottery, it drives up demand for H-1B visas, but how much can it really drive them up? You know?
I'd say it will impact if you allow DACAs to apply for H-1B by way that I don't understand yet.
Hmm.
I would say it will impact somewhat, not as much as you would think, because obviously the specialty occupation requirement.
Hmm.
Now, these DACAs also have had a opportunity for relief based on the Biden new law.
Hmm. Yeah.
So there
That is,
might
which is
be,
totally targeted for those guys as well when they become adults and now they're married and yeah, yeah,
yeah. So uh, I'd say maybe in the final analysis it may not be that impactful, but who
yeah.
knows?
I mean, me, who's really willing to sponsor? There's not that many companies that are willing to sponsor H-1B visas in general. Companies avoid it if they can because it costs money. They pay the costs, and
And then the other thing is the EAD. The DACAs have EADs.
yeah. It's a very, very common thing. Companies that are willing to sponsor H-1B visas. Whoa, you have an EAD? I would like to do that, so I don't have to worry about 30 different compliance components of an H-1B visa.
Yeah.
You know?
So yeah, it's interesting.
Yeah,
It'll be interesting, but difficult to answer um, based on there's a lot that we don't know.
yeah, yeah. So a couple
All right,
questions
Brian.
here.
So 7:01. Let's take the
Yeah,
last question, and we can push it until next week, and
yeah.
we will
So
answer more questions next
let's
week.
make this last question, which is comes right around to the beginning of what we were talking about here, Sam. Has the parole in place already been approved or made law or put into effect, or is it just an idea that Biden is having? So I am going to be a good steward of information, and I'm going to go to www.uscis.gov, and I'm going to click this link right on the main homepage that says process to promote unity and stability of families. And I'm going to Control C, Control V, and put that link into the chat here. And what you will find is that they talk about they have some links there, and they basically one of these pages explains when it will be implemented, and they will be a publication in the Federal Register. It's not in effect yet. They will announce more details of it soon, essentially.
But I thought the question is parole in place is a new thing, or has it been in the books forever? It's been in the books forever.
Yeah, yeah. I guess that's another way. Yeah, the parole in place has been
It's not an
around.
idea. Parole in place has always
Yeah,
been there for decades,
yeah,
and the use of it has been very limited and restricted.
yeah.
So
It's the
what he does is basically turn the spigot on it. He just
yeah,
opened it up.
yeah,
It's been there, and it's a smart way. I mean, it's a brilliant way because the fear is the legal challenge, and if he or the administration does a good notice in the Federal Register, because they can do notice only
yeah,
or they can do notice and comments.
yeah.
Notice and comments takes more time.
Yep,
Notice only takes less time.
yep.
Obviously, he's under the gun because election is around the corner.
Hmm.
So he may do notice only.
Yeah,
And if
and
he does notice only, meaning it's more susceptible to challenge.
yeah, yeah, and I forget the rules as to when they can do either one of those things.
Yeah, I
Yeah,
think he's going to take the position that the regulations are in place already. We're just implementing. We're just giving you notice that we're going to be,
are changing
um,
our interpretation of what is a
yeah,
humanitarian concern, something along the because they
yeah.
said he was planning to implement it later this summer. You know, because I watched that announcement
So that's
live.
basically 60-day only, notice only,
Yeah,
and which
yeah,
means it's going to have a legal challenge, but they feel strong that it's going to survive, or it's going to be by the time it's challenged and turned, it will be 500,000 adjustment status filed
yeah,
and
and getting
money
at least the
collected and
benefit of a pending.
EADs
Yeah.
issued. I mean, yeah, so it'll be interesting.
In terms, just my last thought on that subject, Sam. Obviously, you had mentioned that there's a political benefit. You know, it's getting, courting some votes by helping people who U.S. citizens, right? I can't. I don't. I think the other side. If the other side is going to be fighting against it, railing against it, I don't think that political theater is bodes well for them. It's if there's this one side that's fighting against it and one side that's fighting for it. You know, if you want trying to court votes of a certain demographic,
Yep,
you
yep,
don't want to be
absolutely.
associated with that legal fight against it, I guess. Yeah.
Yep,
Yeah.
absolutely. Well, thank you guys for listening to us. Hopefully, it was helpful. 6 o'clock next week on Monday, and we will talk a little bit more about your questions and a topic of your interest. Have a great rest of the week.